medical malpractice and what you need to know. Hi everybody, this is Sagisha Cat and Joel Roth. We're coming to you today to talk about medical malpractice, the 101 on what you need to know for your claim and make sure your lawyer is doing the things properly to protect your case. So we'll start off first. In medical malpractice, can you just file a lawsuit right away?
No.
Okay, tell us why.
Medical malpractice is a type of case that is unique in Florida law. There are statutes that prescribe how the claims are prosecuted, how the claims are handled, how you can present them, and what you need to do before you can even file a lawsuit. You have all kinds of hoops and hurdles that you have to jump over and through. And if you don't do that strictly and comply and dot all your I's and cross all your T's, your case could actually get thrown out.
So Joel, tell us, how long is the statute of limitations for in a medical malpractice case?
Generally, the statute of limitations, the time in which you have to file suit, is 2 years. The question becomes 2 years from when? Generally, it would be from the date of the incident, but people don't always know that they were the victim of medical malpractice on the date of the incident. So we like to use the date of the incident just to be safe and make sure there were no problems.
Okay, so now after you figured out your statute of limitations, what's the next step? You've gotten the medical records, you realize there's medical malpractice. You told us that we can't file a lawsuit right away because that's the law. So what's the next step that you should do once you have a medical malpractice claim, you've reviewed it, and you think there's a case?
Once we have reviewed a client's file and medical records, and we believe that there is a medical malpractice claim, we then have to send the file out and the medical records out to a medical doctor to review and to give us an opinion. Now, if it's a nursing claim, it would be to a nurse. But basically, you have to have the file reviewed, and you need to get an affidavit from the medical provider, either the doctor or the nurse, in the same specialty as the person who committed the malpractice. That's very important, because if you get an affidavit from someone who's not in the same specialty, it won't comply with the statute, and again, your case can get thrown out.
Now, when you talk about this affidavit or verified medical opinion of a doctor or a nurse to say the other person did wrong, is that before you file the lawsuit?
Yes.
Okay. And then the question is that what they call the pre-suit period?
Right. You start the pre-suit period by giving the target doctor or nurse or medical provider notice of intent. That's what the document is called. It's called notice of intent to initiate a claim for medical malpractice. And when you send that written notice, you have to include with it the affidavit or opinion of the medical provider, the medical expert. And once you do that, that starts the clock ticking on the pre-suit, what is called pre-suit. Under the law, you have to give them notice, and the target defendant has 90 days in which to review the file and decide whether they want to admit liability or fight the case.